Hello and welcome. I am sharing 2 photos of one of my cats with you. She does not like me. I have 3 cats and she is one who does not like me. She doesn't trust me. The other 2 adore me and I adore them. I adore her too, but she doesn't ever look for me. The other 2 look for me. Anyway, she is posing with one of my autumn decorations, a pumpkin. And I saw her like this today and it was so cute. And she was just rubbing against the pumpkin and she posed for me. She doesn't usually cooperate with me, but she did for these photos. I mean, she is so cute. She's so sweet sometimes, but she really doesn't like me. I adopted all of my cats, the 3 cats that I have. I adopted all of them, and they all have their own personalities. They do all trust me. She does too, but she just likes me the least, and that's okay. She's allowed to have her own opinions, even though I feed her and shelter her and take care of her. It's fine. It's cool. All right. And then this is a recent photo of me just sharing, I guess. And another photo of me. I don't really want to do videos of myself on YouTube. The most you will probably get from me are photos. I am open to doing videos in collaboration with other channels if people want to have me on their channel, but I don't really want to be on video for my channel. I just kind of want to be a voice, like just a voice and not so much a face. Anyway, let's read the Karen Reed defense team's motion for relief. So even though this is old news by now, by today, September 22nd, 2024, I felt it important to make a video about the contents of the motion. It is 37 pages long, so I will try to read through it all if I can in this one video. And I wanted to notate that this is being filed in Suffolk County, Massachusetts, whereas the Supreme Court took place, the trial in the Supreme Court took place in Norfolk County. But it's funny because in earlier videos, I often said Suffolk County when I was referring to Norfolk County. Suffolk, Norfolk, and I don't know about anybody else, but those counties, their names are hard to say without saying the word fuck. Just Norfolk, Suffolk, you have to really pronounce the OL there. All right, so it reads Commonwealth of Massachusetts Supreme Judicial Court. So again, this is the Supreme Judicial Court, not the other court that took in Dedham, Superior Court. So this is Supreme. It's a level above the Superior Court. Karen Reed petitioner versus Commonwealth of Massachusetts respondent. So it's neat how in this, in the Appellate Court, Karen Reed gets to be the petitioner. And it's the Commonwealth of Massachusetts who is the respondent. So I'm just saying it's neat. Anyway. And it is titled The Petition for Relief Pursuant to GLC 211 subsection 3. And it lists Karen Reed's current attorneys. And I did notice that attorney Elizabeth Little is not listed. And I still can't get over how I kept referring to Elizabeth as Ashley in that one video I made about her. It was so silly. But I swear she looks like an Ashley I used to know. That's what it was. But anyway, yeah, Elizabeth Little, the attorney who appeared during the trial, is not listed. So I wonder I wonder where she's at. So anyway, it lists Martin G. Weinberg, attorney for petitioner, provides his address and phone number. Michael Pabian, attorney for petitioner, same address as Martin Weinberg, same office. And then it lists Alan J. Jackson, attorney for petitioner, and lists his address and phone number. And then it lists David R. Yannetti, and it's a different address from Weinberg and Pabian. So I am grateful that Alan Jackson is still in the game. David Yannetti is still in the game. It's just Martin Weinberg and Michael Pabian who are new. And Martin Weinberg is not new. Is not a new attorney by any means. He's a legendary attorney in Massachusetts, but he is new to the Karen Read case. And we did hear him during their oral arguments, and he brought up Rule 27B, and I smiled and felt validated. Okay, and then it provides a table of contents, table of contents, and then table of authorities, because they cite extensive authority here. Brilliantly so. All right. And it keeps going. And it begins. Now comes the defendant, Karen Read, who was aggrieved by an August 23rd, 2024 memorandum of decision and order denying her motion to dismiss on double jeopardy grounds in Commonwealth v. Karen Read, number 22-00117, Norfolk County Superior Court. Honorable Beverly. Not so honorable. Cannone. It continues, the order as it currently stands will result in Miss Read being retried on January 27th, 2025 for the same 2 alleged crimes, including second-degree murder, that a jury of her peers has already unanimously agreed the Commonwealth failed to prove beyond a reasonable doubt following trial. 1000% correct, as we all know, as Judge Beverly Cannone herself knows and considers true and accurate. It continues, because the jury reached a final unanimous decision to acquit Miss Read on those charges, and because there was no manifest necessity supporting the declaration of a mistrial with respect to charges on which the jury unanimously agreed, retrial on such counts would violate the double jeopardy protections of both the federal and state constitutions and the common law decisions of this court, enforcing the protections of double jeopardy. I want to say right now, like, I'm getting chills, I'm getting goosebumps reading this, because I'm seeing 4 powerful attorneys. You know, these are the words of 4 powerful attorneys, and they're superb. Alan Jackson is superb. David Yannetti is superb. And Martin Weinberg. They are all excellent attorneys, and I'm just getting chills reading this, because I just love them, and they do excellent work as attorneys. Okay, continuing to read. Miss Read seeks relief from this court through the discretionary superintendent's powers under GLC 11, subsection 3. In support of this petition, the defense has submitted a memorandum of law incorporated herein and has attached a record including the following documents. And it lists the documents. The transcript of the charge jury, transcript of jury trial, defendant's motion to attend the jury verdict slip, transcript of jury, transcript of jury, transcript of jury trial, defendant's motions. I'm not going to read it all, but again, I will, as I do always, I will leave the link in the description below. Continuing, under GLC 211 subsection 3, the Supreme Judicial Court has general superintendence of all courts of inferior jurisdiction, to correct and prevent errors and abuses therein, if no other remedy is expressly provided, and it may issue all writs and processes to such courts which may be necessary to the furtherance of justice and to the regular execution of the laws. Yeah, let's hope this Supreme Judicial Court follows through with exactly that, especially in this corrupt case. It continues, quote, a criminal defendant who raises a double jeopardy claim of substantial merit is entitled to review of the claim before she is retried, end quote. And, quote, GLC 211 subsection 3 is the appropriate route for obtaining that review, end quote. And it provides case law citation. I'm going to read the quote. Quote, because the double jeopardy right is a right not to be tried, end quote. This court has, quote, held that appellate review of the denial of a motion to dismiss on that basis after trial and conviction would not provide adequate relief of the defendant. If the defendant were to prevail, end quote. And it provides case law. Another quote, the rights conferred on a criminal accused by double jeopardy clause would be significantly undermined if appellate review of double jeopardy claims were postponed until after conviction and sentence. This court has long recognized that the double jeopardy clause protects an individual against more than being subjected to double punishments. It is a guarantee against being twice put to trial for the same offense, end quote. Yeah, it sure is double jeopardy. It's there for a reason. Okay. It continues. Request for oral argument. Miss Reed respectfully requests that the court hold oral argument on this petition. Okay. And it reads, introduction. The ancient right to a jury trial is no mere, quote, procedural formality, but rather a fundamental reservation of power to the American people, end quote. Erlinger versus United States. Quote, by requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. And it's quoting the Federalist, number 83, page 499. Okay, continuing. Quote, prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury, end quote. Quote, resumes, after securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty, end quote. Heart and lungs of liberty. It continues, it follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. See Commonwealth versus Taylor. And I'm going to read the quote. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Provides case law. Quote, the double jeopardy clause provides that no person shall be subject to the same offense to be twice put in jeopardy or of life or limb, end quote. Bluford versus Arkansas. Another quote, The underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. End quote. Excellent case law to cite for this. Yeah, and it's what I talk about. The state, with all of its resources, like, they shouldn't be able to abuse their power. Okay, continuing. Quote, even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted. Consequently, as general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. End quote. So far, guys, I'm pulling away from the motion, but so far it is mostly quotes from case laws. They have hardly begun to write their own words. They use some of their own words, but mostly it has been excellent citation of case law. All right, keeping it moving. It provides more case law. I'll read this quote. At the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Yep, it sure would. This is excellent. I love these guys. All right, Bluford. Okay. Another case law. I'm going to read the quote. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling he to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. And I do remember them citing this case law in previous filings, and it is true. It is applicable. You know, unlike Judge Beverly Cannone and her filings, she just uses case law after case law, much of which does not apply to her argument. Okay, continuing to read the motion. Here, the very day after the trial court declared a mistrial, counsel for Miss Reed began receiving unsolicited communications from 5 of the 12 deliberating jurors, in 4 instances directly from the jurors themselves, indicating in no uncertain terms that the jury had a firm and unwavering 12-0 agreement that Miss Reed is not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from one juror to the same effect, nor the Superior Court judge, who expressly credited the veracity of juror statements relayed in affidavits by counsel. She did. I'm pulling away from the motion. She did. This is an excellent point right here. I'm going to read it again. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from the juror to the same effect, so they're referring to the prosecution. So neither the prosecution nor the Superior Court judge, Judge Bev Cannone, acknowledged their statements. And if you remember reading Judge Cannone's filing, her most recent one, she, again, considered their statements true and accurate and did nothing with the information. Okay, I'm going to continue to read. Who expressly credited the veracity of juror statements relayed in affidavits by counsel, disputed the factual basis for the defense motion in any meaningful respect. Given the essential importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. This presents an issue of first impression for this court, as does the defense's alternative contention that Miss Reed was entitled to a post-verdict inquiry to substantiate her claim, and that this court's precedents permitting such inquiry regarding claims of racial bias should be extended to the present context. I need to read that again, guys. And just so you know, this is the first time I'm reading it page to page. Okay, I'm going to read that last one again. This presents an issue of first impression for this court, as does the defense's alternative contention that Miss Reed was entitled to a post-verdict inquiry to substantiate her claim, and that this court's precedents, permitting such inquiry regarding claims of racial bias should be extended to the present context. Okay. All right. Okay, I'm going to keep reading. I want to see where they're going with this. Okay. It continues. Independently, while a jury deadlock constitutes manifest necessity to support a mistrial, there is no authority for the proposition that disagreement as to some counts constitutes manifest necessity for the declaration of a mistrial with respect to all counts. Put another way, there was no deadlock as to 2 of the counts on which the trial court declared a mistrial. The trial court's finding that Miss Reed's counsel consented to the mistrial is contrary to both the factual record and the clear binding case law, placing the burden of establishing manifest necessity solely and exclusively on the prosecution. This is excellent argument. Excellent argument. Continuing. The trial court also failed to address the 2 guiding principles set forth by this court in Taylor, that before a mistrial is declared, quote, counsel must have been given full opportunity to be heard, and the trial judge must have given careful consideration to alternatives to a mistrial. Provides the case law and, okay, it continues. Thus, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution requires the same result, dismissal. The Commonwealth's response on this issue, arguing that inquiry regarding partial verdicts should be prohibited under case law involving lesser included offenses within a single count, unlike the present case, raises an important issue regarding the interaction between the lesser included offense case law and Mass R. Crim. P. 27b, yes, which plainly permits and in fact requires the court, before declaring a mistrial, to inquire of a jury whether there exist partial verdicts where multiple offenses are charged in separate counts. Absolutely. Pulling away from the motion. Yeah, that right there, how they conclude that paragraph is just, to me, it's succinct. It's excellent. An excellent execution of their argument, where they're going with this. And I agree with what they said, that the case law cited from both the Commonwealth and the judge, the case law they cited to me was not applicable because for many reasons. And there were many arguments they both made, the judge and the prosecution. And many of their arguments did not coincide with the case law they were citing. And again, as I have argued countless times in various videos, the judge herself did not follow the rules of criminal procedure. So, and as I have said, she declared that mistrial on her own terms, using her own rules. And I really hope the Supreme Court, like, at the very least, I hope they acknowledge that. I hope they hold her accountable. I hope they write her a letter and the whole world sees it, and they, like, you know, like, they call her out on her bullshit. Like, if you plan to be a standing judge in any other case in Massachusetts going forward, you had better follow the rules of criminal procedure, or else. Like, I really hope the Supreme Court does something. You know, I'm not a genius. I'm just an average person, but I knew that she did not follow any fucking rule. She rushed the mistrial. She wanted to retry Karen Read. Oh, okay, continuing to read. Procedural history. On June 9th, 2022, Miss Read was charged in 3 separate indictments with second-degree murder in violation of GLC 265 subsection 1, count 1, manslaughter while operating under the influence of alcohol, in violation of GLC 265 subsection 13 and a half, count 2, and leaving the scene of a collision resulting in death in violation of GLC 90 subsection 24 to a and a half, 2. A jury trial began on April 16, 2024. On June 25th, 2024, the jury began deliberations after receiving instructions from the trial court. The court instructed the jurors, quote, "You should continue deliberating until you have reached a final verdict on each charge," end quote. June 25th, 2024, at 46 R96. Okay, it continues. It also noted that count 2 contained, quote, "lesser included charges," end quote, of an involuntary manslaughter and motor vehicle homicide, which the jury should consider, quote, "even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor," end quote. Okay, it continues. And I guess I should have said this in the beginning, but I have a stuffy nose. I don't know if it's allergies or if I'm coming down with something. I felt something in my throat the onset earlier. But anyway, if I sound funny or not like myself, that's why. I can hardly breathe through my nose. Okay, continuing. The following day, on June 26, 2024, outside the presence of the jury, counsel for Miss Read raised an issue regarding the verdict form. With respect to count 2, the original verdict slip provided only one option to find Miss Read not guilty, before going on to ask whether Miss Read was guilty of the offense charged or guilty of one of the 2 lesser included offenses. See Exhibit B to affidavit in support of motion to amend jury verdict slip. Counsel asked that the form be amended to provide, quote, "not guilty" options for the subordinate charges under count 2, end quote. June 26, 2024. The trial court initially indicated its disagreement with counsel's request. However, after considering the matter further, the court agreed to provide supplemental instructions and an amended verdict slip. And that is true. Pulling away from the motion, we all witnessed that, how Judge Bev was so, like, having a hissy fit, and, like, it's like the way it's supposed to be. And David Yannetti himself, an established lawyer in the state of Massachusetts, David Yannetti himself, saying the words, "I'm a defense lawyer, and I've never seen a verdict slip like that." Judge Bev very casually saying, whatever. Like, you know, she put up a fight, but then she ultimately agreed to change the verdict slip. We all witnessed it. It was some shady shit. Continuing to read. Later that day, the court provided the supplemental instructions telling jurors that count, quote, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor, end quote. The jury should first focus on that, quote, lead charge, end quote, and, quote, if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order, end quote. It continues. On June 28th, 2024, the jury sent the following note to the court. Quote, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, end quote. June 28th, 2024. The court asked counsel for their views, quote, on whether there had been due and thorough deliberations, end quote, sufficient to support the giving of a so-called Tui Rodriguez charge. Permitting charge if a jury, after due and thorough deliberations, returns to court without having agreed on a verdict, end quote. The Commonwealth responded that the charge should not be given because there, quote, simply had not been sufficient time yet, end quote. June 28th, 2024. Counsel for Ms. Reed disagreed, requesting that the court, quote, read the Tui Rodriguez model instruction and go from there, end quote. The trial court sided with the Commonwealth, ruling, quote, I am not prepared to find that there have been due and thorough deliberations at this point, so I am going to send them back out, end quote. That is what happened. We all witnessed it during deliberations. Pulling away, I'm saying that right now so far they have not lied yet. They have not lied yet, people. These 4 attorneys for Karen Reed in their motion for relief with the Supreme Court of Massachusetts, they have not yet lied. Yep. No surprise to me, of course. But if you remember the Commonwealth's filing, Judge Bev's filing, multiple lies within the first few pages and to the end of their filings, and multiple case laws that did not apply. Continuing to read. On July 1st, 2024, the jury presented another note stating, it's not in quotations, but I'm going to read it. Despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. Yep, remember that one. And it continues. July 1st, 2024. Upon being asked by the court, the parties reiterated their same previously expressed views, with the Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Miss Reed's counsel arguing that the court should give a Tui Rodriguez instruction. This time, the trial court decided to give the requested instruction. Later that day, the jury sent yet another note. Thereafter, without reading the note to counsel and without providing counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges, the trial court simply stated, quote, the jury is at an impasse, end quote, and called in the jurors. Yep. Pulling away, yes. 1000%. That is exactly what happened. That is exactly the argument I have made. Despite Judge Bev Cannone in her most recent filing lying to the defense team, lying to the world as it is a public record, she absolutely lied on public record and said the defense had plenty of opportunity before she declared a mistrial. But she did not provide an opportunity for them. when she said she was going to bring the jury out, and she did not provide an opportunity for them to speak when she declared the mistrial. There was no opportunity given to either the defense or the prosecution. She lied in her filing. She gaslit all of us in her filing. Okay, continuing to read. It then read the note on the record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Yeah, I've read that. I've read all these notes like 10 times with all these filings. Okay, continuing to read. After reading the note and without soliciting the views of counsel in any respect, yes, 1000%, without soliciting the counsel, the views of counsel in any respect, yes, 1000% correct. Okay, sorry, continue to read. The trial court stated, quote, I am not going to do that to you folks. Your service is complete. I am declaring a mistrial in this case. End quote. Yeah, I'm sure many of us will never forget that. We will never forget how she did that on that day. It continues. The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. Yep. Yes, and again, the world witnessed it, and the judge still lied and gaslit the world in her own damn filings. Okay, continuing to read. The following day, on July 2nd, 2024, unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Miss Reed, Alan Jackson. And I just want to notate that I was confused on the timeline as to when these jurors contacted, when they acted following the mistrial. Like how soon, how quickly did they give pushback? And it was immediately the following day. So it's clear here. Okay, it continues. Unsolicited by any party, one of the jurors, Juror A, contacted one of the attorneys for Miss Reed, Alan Jackson. Juror A stated that she wished to inform Attorney Jackson of the true results, end quote, of the jury's deliberations. Affidavit of Alan Jackson. According to Juror A, quote, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was, quote, off the table, end quote, and that all 12 of the jurors were in agreement that she was not guilty of such crime, end quote. The jury also unanimously agreed that Karen Reed is not guilty on count 3, leaving the scene with injury, death, end quote. 1 day later, on July 3rd, 2024, another attorney for Miss Reed, David Yannetti, was contacted by, quote, 2 different individuals hereinafter, Informant B and Informant C, who had received information from 2 distinct jurors hereinafter, Juror B and Juror C, both of whom were part of the deliberating jury in this case, end quote. And then, quote, Informant B sent Attorney Yannetti, quote, a screenshot she had received from someone, hereinafter Intermediary B, of text messages that Intermediary B had received from Juror B, Oh, okay, guys. All right. I'm going to keep reading. In that screenshot, Juror B texted the following to intermediary B, quote, "It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose," end quote. Juror B later placed an unsolicited phone call to Attorney Yannetti confirming that the information contained in the publicly filed affidavit was accurate. See supplemental affidavit. Quote, Juror B clarified, however, that she meant to write, quote, "No one thought she hit him on purpose or even knew that she had hit him." So the juror corrects the typo where it seems that he or she are repeating themselves. So that's all they were correcting the typo. No one thought she hit him on purpose or even knew that she had hit him. So it's like they're saying they were all certain, like they knew she did not hit him. All right, it continues. Juror B told Attorney Yannetti she, quote, "believed that every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3, end quote. Informant C had been in contact with another individual, intermediary C, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C, quote, "No consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlocked at 4 no, 8 yes." Informant C, quote, "Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing," end quote. Intermediary C, quote, "She should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing," end quote. Affidavit of David Arianetti. Miss Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending 1. That the jury reached a final unanimous decision to acquit her on those charges, and 2. That there was no manifest necessity supporting the mistrial given the evidence that the jury was not deadlocked but was instead in agreement on those counts. In the ensuing days after the filing of Miss Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by 2 other deliberating jurors. The first, Juror D, stated that, quote, "that the jury reached not guilty verdicts on count 1 and 3, and that the disagreement was solely as to count 2 and its lesser offenses," end quote. Supplemental affidavit. He recounted that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? Juror D unequivocally told counsel, "Every one of us will agree and acknowledge that we found Karen Reed not guilty of count 1 and 3, because that's what happened," end quote. Quote, Juror E similarly stated, quote, "that the jury was unanimous on 1 and 3, end quote, that Karen Reed was not guilty of those charges." Second supplemental affidavit of Alan Jackson. The Commonwealth filed a post-trial notice of disclosure informing the court that Quote, on Sunday, July 21st, 2024, Assistant District Attorney Adam Lally, the shithead, received an unsolicited voicemail on his office's phone line from an individual who identified theirself as a juror by full name and seat number, end quote. Sorry. Yeah. Commonwealth notice. The message stated, it is true what has come out recently about the jury being unanimous on charges 1 and 3. ADA Lally received a subsequent message from the same individual stating he could, quote, confirm unanimous on charges 1 and 3 as not guilty, and as of last vote 9-3 guilty on the manslaughter charges, end quote. The Commonwealth additionally, quote, received emails from 3 individuals who identified themselves as jurors, end quote, and, quote, indicated they wished to speak anonymously, end quote. The Commonwealth declined to substantively respond to the voice messages or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters. Yeah, ethically prohibited, like the Norfolk County District Attorney's Office really cares about ethics. We all know they don't. Continuing to read. After hearing oral argument on August 9th, 2024, on August 23rd, the trial court issued an order denying Ms. Reed's motion to dismiss. The court, quote, accepted for the purposes of the motion to dismiss, the juror statements quoted in the defense affidavits were true and accurate. Yes. Quote, true and accurate. Yes. Thank you. These smart, intelligent attorneys. Okay, continuing to read. Order at 9, emphasis added. It went on to hold, however, that, quote, because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges, end quote. Yeah, because Judge Bev is a douchebag. Continuing to read, the court similarly rejected the defense argument regarding lack of manifest necessity, finding that A, Ms. Reed's counsel consented to a mistrial via their failure to object, and B, the jury notes reflecting an impasse established the requisite manifest necessity. The court did not address the Taylor test for declaring a mistrial based on manifest necessity, nor did it address Ms. Reed's contention that the burden of demonstrating manifest necessity is squarely on the prosecutor. The court instead erroneously equated a request for a Tui Rodriguez instruction, which is designated to encourage a verdict, with consent to a mistrial. Yes, I'm pulling away from the motion. That's exactly what I argued in a previous video, people. That the judge in her filing is conflating the Tui Rodriguez instruction as like, it's my permission to declare a mistrial. Absolutely not. Absolutely it wasn't, Judge Bev. You know better. We ain't dumb. You think we're dumb. But the Tui Rodriguez instruction was completely separate from your declaration of a mistrial. It's like she totally used it as like, well, you guys knew that I was going to use the Tui Rodriguez instruction. You knew what it implied. So the fact that you're so surprised that I declared a mistrial is your own damn fault. Like, bullshit, judge. Follow the fucking rules. Stop gaslighting people. Okay, continuing to read. Okay, the court instead erroneously equated a request for a Tui Rodriguez instruction, which is designated to encourage a verdict, with consent to a mistrial. Excellent sentence, people. I'm just savoring that. All right, Continuing. Finally, the court rejected the defense's alternative request for a post-trial inquiry on these issues on the grounds that the request implicated, quote, the substance of the jury's deliberations, end quote. Miss Reed's retrial is currently scheduled to begin on January 27th, 2025. All right. Continuing to read Memorandum of Law 1, or I think that's or maybe it's a Roman number. The jury's unanimous conclusion following trial that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. Quote, what constitutes an acquittal is not to be controlled by the form, end quote, of the action in question, Taylor 486, Mass. Provides case law. Quote, rather the court must determine whether the action, quote, actually represents a resolution, correct or not, of some or all of the factual elements of the offense charged, end quote. Provides the case law. The mere presence or absence of, quote, check marks on a form, end quote, is not dispositive, and provides the case law. Here, the affidavits by attorneys Jackson and Unetti reflect statements by 5 deliberating jurors that the jury had reached a final, unanimous conclusion that Miss Reed is not guilty of counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the results of the jury's deliberations. See affidavit of Alan J. Jackson. Quote, Juror A was emphatic that count 1, second-degree murder, was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime, end quote. Reflecting text message from Juror B, quote, it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him, end quote. And reflecting Juror C statement relayed by intermediary C that there was, quote, no consideration for murder 2, end quote, and Miss Reed, quote, should have been acquitted, end quote, on that count. Supplemental affidavit of Alan J. Jackson. Quote, Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of count 1 and 3, because that's what happened, end quote. Second supplemental affidavit of Alan J. Jackson, quote, Juror E explained that the jury was unanimous on count 1 and 3, end quote, that Karen Reed was not guilty of those charges, end quote. There's multiple quotes within the quotes. Okay, continuing. As noted, above, the trial court accepted the foregoing averments as true facts. And then it provides the C order at 9. Okay, continuing to read. In rejecting Miss Reed's claim of acquittal, the court relied solely upon the lack of an, quote, open and public verdict affirmed in open court, end quote. Order at 10, R303. This reasoning is rooted in a formalism that has been consistently rejected by the United States Supreme Court and Supreme Judicial Court in a string of precedents, I guess, spanning more than 100 years. See Supra page 13, citing cases. Provides the case law, quote, however it may be in England, in this country a verdict of acquittal, although not followed by any judgment, is a bar to subsequent prosecution for the same offense, end quote. Provides the case law, holding that judicial grant of new trial prohibited retrial on double jeopardy grounds, notwithstanding that the state, quote, Code of Criminal Procedure did not authorize trial judges to enter judgments of acquittal in jury trials, end quote. It continues, indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final, unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. And in the context of this highly publicized case, it strains credulity to suggest that if the unequivocal statements of 5 jurors quoted above did not in fact represent the unanimous view of all 12, the remaining jurors would allow the inaccuracy to go uncorrected. Instead, they would predictably have notified the Commonwealth or the court of their own recollection. I just gotta go back and read that, guys. There is some passion here, and it is beautiful. I'm gonna read it again. Indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. This is the 4 attorneys arguing on behalf of Karen Reed. That don't you know that she was acquitted on count 1 and 3 unanimously by all 12 jurors, and surely it cannot be the law that we must not acknowledge it. Like they're saying like where are we? Like where are we all living? Like there are rules here for a reason, and a unanimous decision, a unanimous verdict is enforceable. It should be acknowledged. It is merely the Commonwealth, the prosecution, and the judge herself refusing to acknowledge it. And she does not follow any rule. She merely cites case law, much like the prosecution. They don't, even Adam Lally himself, Adam Lally so disgustingly responded to Martin Weinberg's argument, where Martin Weinberg cited Rule 27B of the criminal procedure. And even Adam Lally himself tried to say, Rule 27B doesn't really apply. It doesn't really, like, he tried to make up his own fucking rule, people. Like, Judge Bev, as a judge, has rules she must follow. And before declaring a mistrial on multiple counts, she was supposed to follow Rule 27B. Before declaring a mistrial, she was supposed to mandate that the jury give her any verdicts that they did agree on. But she did not. She didn't follow any fucking rule. And Adam Lally knew that she didn't follow any fucking rule. But Adam Lally still tried to argue that Rule 27B was not applicable when it absolutely was applicable. So I'm just saying, I love that these 4 attorneys are like using their brain power together in this atomic bomb of truth against the judge and her bullshit, as well as the Commonwealth. And they're saying, surely that cannot be the law. Indeed, it must not be the law. Like, yeah, the woman was acquitted. She was found not guilty on count 1 and 3, and she should have been acquitted. The only appropriate response was acquittal, not ignoring what the jury said, not ignoring the rules of criminal procedure. Like, the judge herself just ignoring, whether it was the rules or the procedure or the jurors themselves, just completely ignoring and choosing the outcome that she wanted for this trial, for this case. You know, she and the prosecution so clearly on the same bandwagon. And they're just plowing through, not giving a fuck about any rules or procedures. So I'm saying thank you to the Karen Reed defense team for their passion here. I have seen it. I've noted it. It's beautiful. All right. I'm going to continue reading. Here, to the contrary, the Commonwealth has received the exact same information as the defense regarding the jury's unanimous agreement to acquit Miss Reed on count 1 and 3. Exactly. Continuing the read. The United States Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during deliberations that the jury, quote, was unanimous against, quote, the charges of capital murder and first degree, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily upon the lack of finality of the jurors' report. Quote, the jury's deliberations had not yet concluded, end quote, and it, quote, went back to the jury room to deliberate further, end quote. Quote, the foreperson's report was not a final resolution of anything, end quote, and there was no indication at the conclusion of deliberations that quote, it was still the case that all 12 jurors believed the defendant was not guilty of capital or first-degree murder, end quote. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted through the end of deliberations and following. Yeah, that the juries didn't wait, people. I'm pulling away from the motion. That the jury members did not wait to push back, to protest, and that they basically spent the next month, they spent the entire month of July pushing back and saying, what are you going to do about those verdicts? What are you going to do about those verdicts? They reached out to the defense, they reached out to the prosecution, and they reached out to other people, to their friends and coworkers. Like, the jury was not like silent and just like, oh well, mistrial, whoop-de-doo. No, they were passionate. The jury members were themselves like, what the hell? Like, she should be acquitted on count 1 and 3. And despite their efforts, the prosecution and the judge, again, just ignored them. And the prosecution and the judge, by doing so, proved without a doubt, they proved that they are in cahoots together. How the judge and the prosecution have the same exact reaction, which is to ignore the jury, and the only people doing the right thing is the defense team. It's so crazy, guys, how this is so similar to what happened the night of January 28th into the morning of the 29th, 2022. How so, like, Karen Reed was outnumbered by multiple corrupt individuals, and she was the only one trying to do the right thing. That when everybody figured out that John was on the lawn, right? Like, whether they placed him there, what have you, Karen Reed coming across his body, being the only one trying to do the right thing, and yet she gets framed for it. Everyone else who knew he was there hours prior, everyone else who knew John O'Keefe was there freezing to death, at least at 2:27 a.m., freezing to death for hours before they bring Karen Reed to the scene strategically. And Karen Reed is the only one doing the right thing and trying to warm him, taking off her shirt to warm him. But Brian Albert and Nicole Albert, the homeowners, couldn't be bothered to come outside. You know, living in New England their whole lives, like they've never walked in a snowstorm before. like being members of law enforcement, like they, right? Like they didn't do a damn thing. They did not care about John O'Keefe. It was so clear. It was so clear that there was a group of corruption. They were a group of corruption, and Karen Reed was outnumbered. And the same thing is happening here in these filings between the defense, the prosecution, and the judge herself. That if you just look at all of their filings, it is so clear that the defense are the only ones trying to do the right thing, but they are outnumbered by the prosecution and the judge. All right, continuing to read. Okay. The contrast with a juvenile versus Commonwealth 392 is even clearer. In this case, after the conclusion of trial, a court officer found 4 verdict slips in the deliberation room, 2 of which reflected entries of, quote, not guilty. There was no indication as to when the entries were made or in what circumstances, much less that they reflected a final unanimous conclusion of all jurors. Neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because such final unanimous agreement was not announced in open court. That's true. I agree. Excellent point. Continuing to read. Counsel arguing that Commonwealth had not cited, quote, a single case with facts like this that have been ignored. Not a single precedent have they raised. Sorry, I'm getting confused here. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted, end quote. The instant case squarely presents that issue, and the defense respectfully submits that this court should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. This issue is one of existential importance, not merely to Miss Reed, but to the very foundation of the constitutional safeguards that protect her. So they are Roman numbers. 2. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. The law is clear that at least in the context of juror bias, an affidavit by counsel is sufficient to entitle the defendant to a, quote, post-verdict inquiry, end quote, on the issue. Commonwealth versus McCaleb. Okay, continuing to read. No less than the right to an unbiased jury, it is, quote, a fundamental tenet of our system of justice, end quote, that a defendant may not be retried for a crime of which she was previously acquitted by a jury, and the defense submits that post-verdict inquiry is equally warranted to the present context. Other than generally noting that this case does not involve an allegation of juror bias, the trial court did nothing to distinguish McCaleb. Excellent point. That previously the Commonwealth, I believe it was the prosecution, tried to say that the rule that the defense was arguing only applied when it came to juror bias, which again was a redirection of argument. It wasn't. It's like, you're giving us a really good argument, we're going to throw back another argument and make it look like you're using the wrong argument, when in fact when in fact it was the prosecution and the judge herself who were using the wrong arguments, citing case laws that did not even apply. So I'm just grateful that Karen Reed has such an effective defense team. She has a powerhouse for defense team. And they are calling out the bullshit left and right between the prosecution and the judge. And they're doing it so eloquently. Okay, continuing to read. But there is no apparent reason to limit a defendant's entitlement to a post-trial inquiry to the issue of racial bias alone. Recently, in United States versus Snarve, I can't say it, the First Circuit Court of Appeals remanded the matter for further proceedings in the Boston Marathon bombing case due to 2 jurors' postings on social media, quote, regarding the bombings and the district court proceedings, end quote, which came to light after the jurors had been provisionally selected to serve. The comments did not reflect racial bias in any way, but rather possible bias specific to the defendant. The comments were also inconsistent with the jurors' assurances that they had not discussed the case online. The First Circuit held that the district court erred by failing to inquire about these issues with the jurors, given that, quote, the right to an impartial jury is a constitutional bedrock. When there is a plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie, and if so, why, end quote. Crucially, for present purposes, the First Circuit ordered the district court to voir dire the jurors. In doing so, the court acknowledged, quote, no doubt any juror would have strong incentives to avoid admitting having committed perjury during voir dire. We also expect that most jurors, having taken time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have that verdict disturbed, especially as a result of their own actions. We have no doubt that the able district court judge can do what judges regularly do, form a considered opinion about the sufficiency of the jurors' explanations once those explanations are given and explored. In another high-profile case, the South Carolina Supreme Court recently agreed to hear claims by Alex Murdaugh that during his murder trial, the clerk of court improperly influenced deliberating jurors. See State versus Murdaugh. the Murdaugh murders. Continuing. Order attached hereto as Exhibit A. Jurors came forward after the clerk published a book about the trial describing her, quote, efforts to obtain, end quote, a, quote, guilty verdict through improper jury tampering, end quote. Brief of appellant attached here to Exhibit B at 2. The clerk allegedly told jurors after the defense began its case not to let the defense throw you all off, or distract you or mislead you, and warned them, quote, not to be fooled by Mr. Murdaugh's testimony in his own defense, end quote. Yep, that was some crazy shit. Okay. The trial court held an evidentiary hearing on the motion for new trial, including testimony by jurors. The issue was not racial bias, but nonetheless implicated fundamental constitutional rights like Miss Reed's right not to be retried for offenses of which she has already been acquitted. Yep. And pulling away, it's like Judge Bev is saying, well, I didn't acquit her. The jury acquitted her, but I didn't acquit her. I declared a mistrial. So you guys got to take it up with someone else. And they sure as hell did, didn't they? They sure as hell did file an appeal. And I really hope she goes down for her corruption, Judge Bev. Continuing to read. The trial judge dismissed Miss Reed's reliance upon Sarnav and Murdahl in a brief footnote simply stating that the circumstances, quote, are readily distinguishable, end quote, from those at issue here. But this misses the forest for the trees. I'm sorry. I gotta zoom in or something. Okay. But this misses the forest for the trees. While it is certainly true that all three cases raise different issues, the fundamental point remains the same. A defendant who comes forward with credible evidence of a serious constitutional violation post-trial is entitled to an opportunity to prove those claims. There is no apparent reason to artificially limit the availability of such constitutional inquiry to the singular context of racial bias. The defense request does not in any manner infringe upon, quote, the substance of the jury's deliberations, end quote. To the contrary, the motion to dismiss was predicated solely upon the result of such deliberations, namely a unanimous decision that Miss Reed is not guilty of murder in the second degree. Pulling away. That's exactly what I argued. That's exactly what I saw. That's exactly what I saw in their motion to dismiss. And I did witness in the prosecution's response and in the judge's own filing, I witnessed how they both sort of said, it would be unethical for us to go into deliberations. Like, just, again, changing the argument. They're doing a switcheroo. That's what you're arguing? Well, this is what we're arguing. It's like, let me distract you with a completely different argument from the one you're making. Because that's exactly what, like, abusive people do, right? And that's exactly what the prosecution and Judge Bev did. They both took the defense's valid arguments, the jury members' valid arguments, and they gaslit all of us by saying, this is what you're actually arguing, and we can't do that. You want to go into deliberations? That's unethical, right? That's what they did. And at no point in any of the defense's filings was there any request verbatim to go into the deliberations. There was only a request to acknowledge the verdicts that were made, which the judge failed to announce in open court. She failed to follow Rule 27B, which gave her permission to require the jury to give her those verdicts. Had she followed that rule, then Karen Reed would have been acquitted on count 1 and 3 that day, people. So I'm grateful that the defense team is making that argument. They are writing it in stone, that they were not asking about the deliberations. They were asking about the result of the deliberations, the fucking verdicts. Okay, continuing to read. The relevant inquiry could be accomplished by a single, quote, yes or no, end quote, question posed to jurors. Yes, I swear. Okay, pulling away. I swear I made that same argument. Like, why? What is so complicated here, Judge? You have that big ass chambers for a reason. Your chambers is probably bigger than the courtroom where the trial took place. You got that comfortable chambers, right? You just bring all those jury members back into your chambers and you ask them, yes or no. What was your verdict on count 1 and 3? Yes or no? Was it guilty? Was it not guilty? Boom. You're acquitted, Karen Reed. It was that simple. That's all she had to fucking do. But she wouldn't do it because she does not care. She does not care, much like the prosecution doesn't care. They have an agenda here.
And through their own actions, through their own publicly available actions in their own court filings, they proved that they are in cahoots together. Okay. Continuing to read. Yes or no question posed to jurors. Did you unanimously acquit Karen Reed of the charges in counts 1 and 3? Of course, the results of a jury deliberations are not secret. They are, in fact, routinely announced in open court. Here, the defense has learned post-trial that the jury reached a verdict that was not so announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Miss Reed is not unconstitutionally forced to stand trial for criminal offenses of which she has already been acquitted. Such inquiry in no way intrudes on the deliberative process of the jury. Thank you. It's a similar argument I made in a previous video pertaining to the judge and the prosecution's bullshit filings. In no such way does that inquiry go into the deliberation process. You know, it's like, but we all know this. I knew it. People reading the filings, we all know this. We all know that the defense never once asked to go into the deliberations. And yet, the prosecution and the judge and multiple mainstream news sources, even NBC 10 Boston, NBC 10 Boston that's been like covering the protests, you know, and interviewing Karen Reed supporters, even they brought on the dean of the Andover Law School in Massachusetts. And even when he changed his fucking argument. He went from saying she should have followed Rule 27B to saying, well, we really can't go into the jury deliberations. And then there was another fucking lawyer from New Hampshire, I think, that the NBC 10 Boston brought on Canton Confidential. And she too said the same thing. We really can't go into jury deliberations. When at no point, again, those were two fucking lawyers on TV, on national television. Like, they didn't even read the filings from the way they were talking, or they were given those arguments to say on air. How could two different attorneys just regurgitate the same argument that wasn't even mentioned in the defense's filings? We really can't go into jury deliberations. Like, just that argument was just repeated between the prosecution, the judge, and even attorneys that some mainstream news sources had on their panels. Just, again, that's how you confuse people about the argument. What's the actual true argument here? You got to follow it carefully, because the ones who are trying to obfuscate are going to try to confuse you on what the argument is. And that's exactly what the judge and the prosecution tried to do. They tried to make us feel like they were confused, or they tried to confuse us. But ultimately, it's obfuscation. It's taking the true argument and saying, well, that's not what you're really arguing. This is what you're arguing. It's such shit. It's such bullshit. And it's all intended to achieve the outcome that the state wants. Okay, continuing to read. All right. Indeed, it was the trial court, not the defense, that injected issues regarding jury deliberations into the inquiry. Yes. I'm pulling away. It was not the defense who asked or inquired about the deliberations. It was the trial court and the prosecution. It was the prosecution and the judge who brought up the deliberations in the first place. In the fucking first place. The defense never mentioned the deliberations in their arguments. It was the prosecution's response and the judge's filings herself. Again, obfuscation. Okay, continuing to read. It is simply not true that, quote, given the content of the jury's final note to the court, any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on charges when post-trial. Certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges, end quote. As explained in front pages 28 through 29, in light of the trial court's instructions repeatedly characterizing the lesser included offenses within count 2 and discrete charges, the jury's note is readily susceptible to interpretation consistent with the post-trial evidence supporting the defense's motion. In any event, if the jurors state that they acquitted Miss Reed, no further inquiry regarding the contents of the jury note could possibly remove the clear constitutional implications of such acquittal. Yeah. Yeah. Just reading that last one. In any event, if the jurors state that they acquitted Miss Reed, no further inquiry regarding the contents of the jury note could possibly remove the clear constitutional implications of such acquittal. Exactly. But, like, it's guys, in terms of the judicial process, in the criminal court process, again, a real judge, a judge doing his or her job, would look at what the jury said post-trial, and they would bring them in and say, you guys had verdicts. I am so sorry. I did not know. I misunderstood your last note. What were your verdicts? Because the fate of the accused actually, literally depends on those verdicts. That's what a real judge would do. They would finish their fucking job. Judge Bev not only does not want to follow any rule, she doesn't want to finish her job despite not following any rule. She wants to keep doing whatever she wants to do. That's what's so aggravating and frustrating. And what the defense is saying here so excellently, they're executing it so it couldn't be louder, people. The defense's point couldn't be louder here. That hello, they had verdicts, and Judge Bev, you're really gonna argue that the verdicts can be ignored because Karen's constitutional rights are only applicable if those verdicts are read in open court, when you know damn well you didn't even follow the rule that would have permitted them to be read on open court. Like, the defense is saying there were verdicts. So, like, any argument you have to make thereafter is mute. There were verdicts. She was acquitted by the jury. You just didn't allow the jury to speak in open court, right? Like, that's what the defense is trying to say. Like, technically, she was acquitted, whether you acknowledge it or not, Judge. How could you possibly overlook? How could you possibly go beyond that and just keep walking like nothing? They were verdicts, unanimous verdicts on counts 1 and 3. How could you possibly sleep at night saying, like, you snooze, you lose? Like, well, they weren't announced in open court. What kind of judge are you, Judge Bev? All right, continuing. This is part 3. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. Absent the defendant's consent, quote, state and federal double jeopardy protections bar, as a general rule, retrial of defendant whose initial trial ends without a conviction, end quote, provides the case law. This rule is rooted in the, quote, importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate, end quote, provides the case law. Quote, the double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal, end quote, provides the case law. Quote, thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial, end quote. Wonderful. That's an excellent citation of case law. And it applies, guys. It applies. You know, this isn't the defense trying to make you dumber by giving you case law that doesn't apply, unlike the prosecution and Judge Bev. They are providing case law ethically as it applies to Karen Reed's case, as it applies to what happened during and post-trial. Continuing to read. Importantly, the heavy burden of establishing, quote, manifest necessity, end quote, to justify a mistrial is exclusively on the Commonwealth, provides the case law. And this burden remains solely upon the Commonwealth regardless of whether or not a defendant objects to the declaration of a mistrial, provides the case law. Before a court declares a mistrial for manifest necessity, quote, I, counsel, must have been given full opportunity to be heard, and two, that was a one. I thought it was an I. Okay. One, counsel must have been given full opportunity to be heard, and two, the trial judge must have given careful consideration to alternatives to a mistrial, provides the case law. Here, the defense respectfully submits that the lack of opportunity to be heard alone is dispositive. Upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. This action, quote, was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel, end quote. So they cited a case law in which a similar thing happened, in which the action was sudden, brief, unexpected, and neither preceded nor accompanied by discussion with counsel. And that's exactly what happened when Judge Bev declared that mistrial. It was sudden, it was brief, it was unexpected, and even the jury members themselves had to take action the day after. So it wasn't just unethical against the counsels themselves, the attorneys themselves. Even the prosecution, she didn't give the prosecution a chance to speak, even though she's in cahoots with them. And even the jury, it wasn't just against the counsel, but it was also even against the jury, that she rushed it. And then the jury had to work even more. Like the jury didn't work hard enough. That's another aggravating factor here. She didn't make the jury work hard enough. She made them work even after trial because she never gave them the opportunity to tell her that they had verdicts. And they worked for weeks after trial, post-trial, calling to the defense and calling to the prosecution to tell them that they had verdicts. And yet, even in the judge's most recent filing, her final filing, she does not care. She doesn't care about the work they did during trial, during deliberations, or after trial. She does not care about the efforts they made. And I really hope the Supreme Court looks at her and reprimands her. I hope they write something that is forever on public record about Judge Bev Cannone, and I hope they use her full name. And I hope she steps down and stops being a fucking lawyer. I hope she finds another job, you know? I really fucking do. She should not be a judge. Okay, continuing to read. Finding no manifest necessity where no, quote, no opportunity was given counsel to argue the propriety of the question or of the necessity of a mistrial, end quote, provides the case law. Finding no manifest necessity where, quote, the judge first ruled that he was going to declare a mistrial and then, almost as an afterthought, unenthusiastically asked whether counsel objected, end quote. That was another shitty judge. Okay, continuing to read. The defense was provided no opportunity to object to the declaration of a mistrial or to advise the court of the imperatives of mass ar crim, request that the jury be polled, or discuss the issue with Miss Reed. The defense respectfully submits that given the importance of double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. And it provides the case law, observing that, quote, some basic trial choices, end quote, including the choices, quote, to plead guilty, waive a jury, testify in her own behalf, or take an appeal, end quote, are so important that an attorney must seek the client's consent in order to waive the right, end quote. It's compelling case law that they're citing. Continuing, arguing that counsel had, quote, no opportunity to speak to Miss Reed. After all, it's her rights, not theirs, end quote. Counsel for Miss Reed clearly had no such opportunity here. Whether or not the trial court was obligated to obtain Miss Reed's personal consent, its failure to at least ensure that counsel had an opportunity to consult with Miss Reed on the issue undermines the existence of manifest necessity. Yeah. Again, I'm still getting some goosebumps from how well put together this filing is. This is, it's impeccable. Okay, continuing to read. The record is independently lacking on the second prong, as it reflects no, quote, careful consideration, end quote, of, quote, alternatives to a mistrial, end quote, provides the case law. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. This option is apparent from the face of Mass R. Crim P. 27b, which states that the judge, quote, the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, you guys know I read this, I cited this, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. Yes, recorded. And what's another, and when they say recorded, what they're also saying, another way of saying it, is announced in open court, put on the record, recorded. And she didn't do anything in 27B. She didn't do the first part. She didn't do the second part. She didn't do the third part. She didn't do shit. She followed her own rules. Continuing to read. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. Yes, it is required, Judge. You were given the permission to require the jury. That's what Rule 27B of the Massachusetts Rules of Criminal Procedure give you. That's what you, as a judge, have to follow, the rules. And you did not. You did not. And you screwed over the jury left and right, despite not following the rules. And guys, it's just like, it's like that guy that worked at the gun shop, and he was on that show, and I made a video about it, and I pissed off a lot of people because, you know, I believe in the right to bear arms. And anyway, the guy who witnessed Brian Higgins losing his shit, and Brian Higgins at no point turning around, Brian Higgins at no point stopping himself to say, I'm doing the wrong thing. I'm doing the wrong thing. Holy shit, I'm doing the wrong thing. I should probably stop. And just take some accountability here, because taking some accountability here is actually the easiest route. And it's actually the route with less suffering. If I just take some accountability for my own shit, then I won't have to take that girl to the grand jury for something I know she didn't do, right? But that wasn't Brian Higgins. He said, nope, I have a reputation, I have an ego, I'm a beta male, and I'm right, damn it. And nobody says no to me. Nobody at a gun shop says no to me. I'm an ATF agent. And I'm going to push that girl. I'm going to take her all the way to the grand jury. And I'm going to keep doing the wrong thing. I'm going to waste taxpayer resources. I'm going to waste everybody's fucking time on this fake ass charge that the grand jury ultimately dismisses because the girl was innocent. You know, that was Brian Higgins. Instead of stopping himself from doing the wrong thing. Like, if you fuck up, right? Then stop fucking up. Just stop. Stop where you're at and turn around. You know, take some accountability and stop. Start doing the right thing, but not Brian Higgins and not Judge Bev. She will not follow the rules, and she will just keep going, not following the rules. She will keep fucking up. She will fuck up and keep fucking up. That I'm saying, like, these are the people that Karen Read was surrounded by before she was accused of being a murderer, during her trial, and after her trial. She is still surrounded by people in positions of power who want to keep doing the wrong thing. Okay, continuing to read. Sorry, huge digression. Okay. Required before a mistrial may be declared for manifest necessity. Quote, this rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. End quote. Had the court inquired as to the existence of any partial verdicts, the jury articulated its verdicts consistent with the statements of Juror A, Juror B, Juror C, Juror D, and Juror E, the double jeopardy implications would have been clear and decisive. Quote, indeed, with virtual unanimity, the cases have applied collateral estoppel to bar the government from relegating a question of fact that was determined in defendant's favor by a partial verdict, end quote. Quote, when the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached agreement, end quote. In denying the motion to dismiss, the trial court erred by relying primarily upon the lack of objection by defense counsel. In doing so, it utterly neglected to acknowledge the clear and long-standing case law placing the burden of establishing manifest necessity squarely on the prosecution. Nicole provides a helpful analog. Okay, continuing to read. The defendant in Nicole, I think I'm saying it right, was charged with operating a vehicle under the influence of alcohol. Only 6 jurors were impaneled, and after trial began, one juror recognized a witness, quote, and informed the trial judge that he might not be able to be impartial, end quote. The judge excused the juror, quote, left with 5 jurors, the judge and attorneys briefly discussed how to proceed. Defense counsel expressed his frustration over the impanelment of only 6 jurors and then stated, I don't think we can go forward with 5 jurors, can we? The judge responded, not in a criminal case. Okay, I'm going to declare a mistrial. End quote. After a retrial was scheduled, the defendant moved to dismiss on double jeopardy grounds. The trial judge allowed the motion, finding, quote, that contrary to his initial understanding, Massachusetts procedural rules would have allowed the trial to continue with 5 jurors, albeit with defendant's consent. The judge, therefore, found that he, quote, had failed to give careful consideration to the alternative of proceeding with the trial before less than a full jury, end quote, and accordingly, quote, there had been no manifest necessity for the mistrial. They're right, because pulling away, they're supposed to seek out alternatives, plural, alternatives before declaring a mistrial. And the only alternative that they sought was the Tui Rodriguez instruction. And it was hardly an alternative. It wasn't really an alternative. It was an instruction. It wasn't even an alternative to the mistrial. It was a, hey, we really need your verdicts. Can you guys please, for the life of you, come up with a verdict? That's what the Tui Rodriguez instruction was. It wasn't even really an alternative to a mistrial. So I'm saying, like, the Commonwealth and the judge, they together collectively are supposed to come up with alternatives to a mistrial before declaring a mistrial. There are supposed to be safeguards against a mistrial, because a mistrial means potentially means that there was a huge waste of resources. That again, the state failed to prove their case. So there was a huge waste of resources. So if you're going to declare a mistrial, that could mean that you're going to want to retry the accused. So therefore, there would be a lot more of resources going forward being used, in order to prosecute the accused. So again, like, there are supposed to be safeguards. You're supposed to seek out alternatives before declaring a mistrial. And the other safeguard, the other obvious safeguard that a judge is supposed to follow, the rules of criminal procedure. Those are another safeguard, which Judge Bev clearly did not follow. So I'm saying, like, there are multiple safeguards here that both the prosecution and Judge Bev were supposed to follow. They were supposed to go along with and not just do whatever they wanted to do. But it is so clear that's exactly what happened. Continuing to read. On appeal, this court began from the premise that, quote, due to the importance of the double jeopardy protection, the Commonwealth bears the heavy burden of proving that a mistrial rested on manifest necessity, end quote. The court has agreed the court then agreed with the trial judge that the defendant could waive his right to a trial by a jury of at least 6. It rejected the Commonwealth's argument that the defendant in the case at hand had not provided such a waiver, observing, quote, "The question is not whether defendant executed a valid waiver, but whether there was a manifest necessity for declaring a mistrial. Such necessity would have presented itself if defendant had declined to execute a waiver, but the record is clear that neither the judge nor counsel was aware of even considered the option." Excellent argument. I'm just pulling away briefly. Excellent argument. Like what the judge and the prosecution are saying, well, you didn't object. You didn't tell us you didn't want the mistrial, when in fact they were not given, the defense was not given an opportunity to object to the mistrial, and the mistrial was declared despite a lack of manifest necessity and despite the judge not following Rule 27B for declaring a mistrial in the first place. You don't just get to declare a mistrial when there are multiple counts in the state of Massachusetts. You don't just get to do that. There's a rule, and it's called Rule 27B. You're supposed to follow that when there are multiple counts, and that's exactly what Karen Reed had. She had multiple counts. Rule 27B of the criminal procedure is a safeguard. It was supposed to be followed, and it was not. Okay, continuing to read. Quote, "In these circumstances, the Commonwealth was unable to satisfy its heavy burden of proving that there was a manifest necessity for declaring a mistrial. The defense respectfully submits that the same result is required here. It is the prosecution's burden alone to ensure that the declaration of a mistrial is supported by manifest necessity, even where, unlike in the present case, defense counsel was expressly offered the opportunity to be heard on how to proceed and explicitly shared the judge's mistaken view that the trial could not continue with fewer than 6 jurors. This court held that the alternative to declaring a mistrial was not adequately considered. Here, there is no doubt that the court was permitted to accept a partial verdict, but the record simply reflects no consideration of that option. Accordingly, as in Nicole, the charges in this matter must be dismissed. Neither Miss Reed nor her counsel consented to the declaration of a mistrial. Consent may be implied, quote, where a defendant had the opportunity to object but failed to do so. Provides case law, but the law is clear that such consent may not be inferred from counsel's silence alone. Provides the case law, rejecting argument, quote, that the defendant consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed, end quote. Provides the case law, holding that where, quote, the trial judge did not ask defense counsel to comment on the possible declaration of a mistrial, end quote. Quote, the lack of an objection from defense counsel cannot be construed as consent, end quote. Here, no such consent was sought, nor was it given. Wow. Yeah. Beautiful. Beautiful. This is beautiful, people. And I really hope you guys read Judge Bev's filing, because this would all make a lot more sense. It would all kind of coincide. It would all come together for you. That she provided so much case law that didn't even apply, case law that was conveniently strategically placed in her non-arguments. And this is the defense providing case law that actually applies. Case law that in fact overrides the case law she provided. So if you haven't read her filing, or if you haven't listened to the video I provided commentary regarding the filing, please do so. And I provided a link to her filing in that video as well, if you just want to read her filing yourself. This motion for relief from the defense to the Supreme Court, it really does. It kicks Judge Bev's arguments in the ass. You know, it's really well done. Okay. It continues. The trial court's ruling that Miss Reed's counsel impliedly, I didn't realize impliedly. I've never used that word, guys. All right. Consented to the mistrial was based primarily upon counsel's request for a Tui Rodriguez instruction. Of course, whether the jury has engaged in, quote, due and thorough deliberations, end quote, to support a Tui Rodriguez instruction, and whether there is manifest necessity to declare a mistrial are distinct legal questions. In fact, the Tui Rodriguez charge is, quote, designed to urge the jury to reach a verdict, end quote, not to avoid one. Yep. Okay. Provides the case law. Unsurprisingly, neither the Commonwealth nor the trial court cited any case finding a defendant's consent to a mistrial can be based on a prior request for a Tui Rodriguez charge. Boom! Pulling away. Boom. Like, yes. That's like an uppercut, you know? It's like witnessing. It's like witnessing the defense and Judge Bev, like, going at it. Like, this is an uppercut. This one knocks her out. Yeah, Judge, what the hell were you saying in your filing that because the defense knew that requested themselves the Tui Rodriguez instruction that they should have known that she would have declared a mistrial? No. The Tui Rodriguez does not give her permission to declare a mistrial. It is supposed to be an alternative to a mistrial, even though it's not really an alternative to a mistrial. It's just pushing the jury to make a decision, to decide on a verdict. I'm again, Karen Reed, she's got angels, someone's looking after her because she has a powerhouse of attorneys who, they're paying attention, they're following, they're picking up what the judge is putting down, and they are fighting back, and they're doing so effortlessly, in my opinion. Sorry, I have to cough. 1 moment. Okay. Sorry. Okay. All right. Sorry if it's obnoxious that I'm clearing my throat into the mic. Okay. It continues. Here, defense counsel's requests did not reflect any implicit consension that the jury was deadlocked on all counts, nor did they commit the defense to any position regarding whether the court should sua sponte declare a mistrial. And sua sponte just means on its own, the judge making an order on its own. The court, aka the judge. Okay, continuing. Declare a mistrial. It is true that if the jury reports an impasse after a Tui Rodriguez instruction, they, quote, shall not be sent out again without their own consent, end quote. The fact, however, does nothing to undermine the alternative of simply inquiring, pursuant to Mass R. Crim P. 27b, whether the jury had reached any partial verdict. Doing so would not require the jury to be, quote, sent out again, end quote. The trial court was in error in equating a request for a Tui Rodriguez charge with any acceptance of or acquiescence to a mistrial. Yes, absolutely. And I made a similar argument when I was reading Judge Bev's bullshit filing. Again, you can check that video out if you want to, but I made a similar argument that it's not the same. A Tui Rodriguez is not permission to declare a mistrial, and that's exactly what Judge Bev implies in her filing. Okay, continuing to read. Moreover, the trial court's characterization of the jury's final note as, quote, making it clear that the jurors would not consent to continuing their deliberations, end quote, is belied by case law cited in the court's order. Provides the case law. Quote, that they felt strongly that there was no hope of progress and requested further instruction, end quote. The court responded by telling the jury, quote, I cannot force you to continue deliberations unless you agree to continue deliberations, end quote, but then asking them, quote, to retire and decide whether further deliberations on the next day would be fruitful, end quote. The jury promptly reached a verdict, end quote. This court held that the object of the statutory prohibition on sending the jury back out without consent, quote, was fulfilled because the jury consented to continue their work. The jury's return of a verdict after sending their last note implicitly satisfied the statutory requirement of jury consent, end quote. Thus, Thus, another alternative to a mistrial, which the trial court did not consider in this case, would have been to A, inform the jury that it could not be required to continue deliberations without its consent, and B, ask it to retire to consider whether it was prepared to return any partial verdict. I 1000% agree. Pulling away from the motion, yes, those are actual alternatives to declaring a mistrial, and the judge did neither. Really good arguments. Continuing to read. Here, neither Miss Reed nor her counsel were provided an opportunity to object to the declaration of a mistrial, as opposed to the appropriateness of a Tui Rodriguez instruction. All of the cases cited by the trial court on this issue are readily distinguishable on that basis. Sorry. Trying to not clear my throat in the mic. For example, in Pellegrin, a witness testified at trial to incriminating evidence that had not been disclosed to the defense. This court held that the defense had an opportunity to object given that the mistrial was declared after a voir dire of the witness and after the jury were cleared from the courtroom. Provides the case law. Oh no, it's providing its own. Okay, continuing. I apologize if the clearing of my throat is getting annoying, people. Okay, here, by contrast, the defense did not learn of the contents of the jury note or the court's intention to declare a mistrial until the judge called the jury in and stated the declaration of mistrial on the record. Counsel was never shown the note from the jury. The judge indisputably never informed counsel of its intent to declare a mistrial, much less solicited counsel's views on the matter. Compare United States versus McIntosh. Ruling in case where, quote, defense counsel at one point implored the district court to declare a mistrial because the jury was deadlocked, end quote. Quote, it would be Kafkaesky, I'm sorry, and wrong to allow parties freely to advocate on appeal positions diametrically opposite to the positions taken by those parties in the trial court, end quote. Provides the case law. After co-defendant moved for mistrial, the, quote, court subsequently stated that it was going to declare one, end quote, and, quote, asked the attorneys if either wished to make any record, end quote. Provides the case law. Quote, defendants had moved for a mistrial. a scant 2 hours before one was declared, at the first suggestion of jury deadlock. As the appeals court has explained in an analogous factual context, the suggestion that counsel could or should have been immediately objected. I apologize. Let me read that all over again. As the appeals court has explained in an analogous factual context, it's a mouthful, and I can't breathe through my nose. The suggestion that counsel could or should have immediately objected to the sua sponte declaration of a mistrial underestimates or ignores the difficulty of reading a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial. The possibilities ahead, such as the appearance of a new prosecution witness, cannot be instantly calculated. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise, end quote, provides the case law. Yeah, and to me, it seems on purpose. It seems like a strategic move to stay on the bandwagon with the prosecution, Judge Bev. But I do appreciate that they refer to her declaration of a mistrial as a sua sponte, as it being sua sponte, meaning on her own, which again I have argued. It was absolutely a sua sponte. She absolutely made her own order on her own terms. And a judge is allowed to do things sua sponte. They absolutely are. But notice that she would not do a sua sponte when it comes to bringing the jury members back in to hear their verdicts and to allow their verdicts to be heard in open court to acquit Karen Reed, right? She'll do a sua sponte to declare a mistrial, but not to honor those verdicts. Okay, continuing to read. The trial court's suggestion that defense counsel had an opportunity to object to the declaration of a mistrial after it had occurred and the jury had been discharged is mistaken. The judge expressly told jurors, quote, "Your service is complete. I am declaring a mistrial in this case," end quote. She sure did. Okay, continuing to read. Given counsel's lack of an opportunity to be heard and the court's lack of consideration of alternatives, the defense respectfully submits that the prosecution has not satisfied its high burden of establishing manifest necessity for the mistrial, while the trial court correctly observed the jury deadlocked may be grounds for a mistrial. It cited no precedent for the counterintuitive proposition that a deadlock with respect to some but not all counts constitutes manifest necessity for the declaration of a mistrial as to all. Provides case law. This is really well written, people. Continuing. Affirming declaration of mistrial where note expressly, quote, stated that the jury could not reach a unanimous verdict as to either, end quote, of the two indictments. This lack of presidential support is no accident. Such a rule would run counter to the important interests underlying the constitutional safeguards against double jeopardy. Contrary to the trial court's suggestion, there was nothing in the jury's notes that, quote, directly contradicted, end quote, the post-trial affidavits by counsel. As an initial matter, there is a facial tension between this observation by the court and its stated acceptance of the affidavits as true for the purposes of the motion to dismiss. Yes. I'm going to read that again. Beautiful argument. Yet again, it reads, as an initial matter, there is a facial tension between this observation by the court and its stated acceptance of the affidavits as true for the purposes of the motion to dismiss. That sentence, what that sentence is saying is what is exactly what I was saying. How can she find that those verdicts are true and accurate? How can Judge Bev in her own filing say, yes, I believe the jury. I believe the jury found Karen Reed not guilty on count 1 and 3, 12-0. I believe they had verdicts. I find those affidavits true and accurate. But at the same time, what is all this then? What is all this then? It doesn't make sense. It doesn't make any sense. How can you say, yeah, there were verdicts, I believe you, but I'm not going to do my job? Okay, continuing to read. And the jury's reference to, quote, charges is easily reconciled with the post-trial affidavits affirming that the only deadlock related to the lesser included offenses of count 2. Indeed, the court repeatedly referred to those lesser included offenses as distinct charges, both in its initial and supplemental instructions to the jury. In this context, the jury's note was facially susceptible to two alternative interpretations. One, that the jury had reached an impasse as to all charges, or two, that the deadlock applied only some of those charges, e.g. on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it, quote, should continue deliberating until, end quote, it had, quote, reached a final verdict on each charge, end quote. The court's holding in Commonwealth versus Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Roth was rooted in the belief that, quote, inquiry concerning partial verdicts on lesser included offenses, end quote, that have not been separately charged, quote, carries a significant potential for coercion, end quote. Provides note of the case law, declining to require court, quote, to consider giving the jury new options for a verdict, end quote, in the form of partial verdicts on lesser included offenses where, quote, under Arkansas law, the jury's options were limited to two, either convict on one of the offenses or acquit on all, end quote. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present where, as here, the jury was asked to return 3 separate verdicts on 3 separate counts. Provides the case law. Distinguishing situation, quote, where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. Provides the case law, quote, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlock on the other counts. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is a straightforward and, the defense contends, constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Excellent argument. Pulling away, excellent argument. Again, the defense is just saying, yeah, they were verdict, judge. They were at an impasse, judge, but you didn't even ask them if they were at an impasse on one, two, or all of the charges. You declared a mistrial without inquiring, judge. Continuing to read, contrary to the trial court's suggestion, an inquiry regarding whether the jury had reached a partial verdict on any of the 3 separately charged counts would not necessitate any forbidden inquiry on the lesser included offenses contained within count 2. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to. The single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts, provides the case law. Affirming trial judges' taking of partial verdicts on 2 of 4 separate indictments and observing, quote, to conclude that the jury could have felt pressure to convert provisional verdicts against the defendant into final ones and to abandon all doubts that they may have privately entertained runs counter to the clear instructions of the judge and amounts to mere speculation without any support in the record, end quote. Really excellent. Really excellent. I would read it again, but it's already long enough, but it's an excellent argument. Yeah. Again, she didn't do her job. She did not do her job, people. Continuing. Noting in the context of deadlocked jury that, quote, Rule 27B permits taking verdicts on less than all of the charges set forth in separate indictments, end quote, provides the case law. Affirming partial verdicts taken after judge asked jury whether it had, quote, reached a verdict on any of the indictments, end quote, provides the case law. Holding that, quote, the judge's decision to take a partial verdict and encourage the jury to agree on the remaining charges was sound, where the jury indicated they were able to reach a consensus on some charges but not others, end quote. Yeah, beautiful. All right, continuing. The inflexible prohibition on judicial inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in, quote, being able once and for all to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate, end quote, provides the case law. And, quote, the danger of unfairness to the defendant, end quote, from multiple prosecutions, quote, exists when a trial is aborted before it is completed, end quote, as well as when the defendant is actually acquitted, provides the case law. The Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some but not all standalone counts. It is uncontroverted that, according to the jury of her peers following trial, Miss Reed was unanimously found not guilty of counts 1 and 3. That disputed fact must not be lost in this analysis. It appears repeating that, quote, at the heart of this policy against double jeopardy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Yeah, they cite it again, and appropriately so.
they're trying to drive that point home. And I agree, the prosecution and Judge Bev, this is nothing short of oppression. When they aren't following any rules and the case law they're providing is convenient but not really applicable. And it's so clear here with the case law that the defense provides in rebuttal. The defense provides case law that actually applies. The defense is keeping it real, whereas the judge and the prosecution are clearly not. And the conclusion: for the foregoing reasons, Miss Reed respectfully requests that this honorable court reverse the trial court and order that counts 1 and 3 must be dismissed. Respectfully submitted, Karen Reed and her attorneys, Martin, Michael, Alan, and David. And then certificate of service, I, Martin G. Weinberg. He served attorney Adam Lally. Really well written. Good job. And these 4 men, these 4 men are the real superheroes of the modern day. And poor Miss Reed, poor Karen Reed. She's been through enough. The state of Massachusetts has done enough to her. And I really hope that the Supreme Court proves all of us wrong, right? That the corruption stops somewhere, because it hasn't stopped yet. It hasn't stopped yet. It didn't stop with the Popo. It didn't stop with the state Popo. And it didn't stop with Judge Bev. I really hope, and I'm sure I'm speaking for a lot of other people, I really hope that the corruption stops at the Supreme Court. And I really hope that the Supreme Court knows that the world is watching. The world is watching. I'm going to read the Supreme Court's response. Okay, in their response, the Commonwealth of Massachusetts, Suffolk County, Supreme Judicial Court for Suffolk County, Commonwealth versus Karen Reed, reservation and report. This matter came before the court, Dewar J., on a petition for extraordinary relief pursuant to GLC 211 subsection 3. Upon consideration thereof, I hereby reserve and report this case without decision for determination by the Supreme Judicial Court for the Commonwealth. The parties shall prepare and file in the full court a comprehensive statement of agreed facts necessary to resolve the issues raised by the petition. The statement shall be prepared in time for inclusion in the parties' record appendix. And it reads here: at a scheduling conference held on September 12th, 2024, following this court's review of the petition, as well as its record appendix containing, among other things, the relevant papers filed by the Commonwealth before the Superior Court, the court expressed its intention to reserve and report this matter to the full court. The court also requested that the parties confer regarding a briefing schedule before the full court, and B, gave the Commonwealth until September 18th, 2024 to file a response to the petition in the county court, if any. The parties jointly filed a proposed briefing schedule on September 17th, 2024. And as I'm reading this, I'm sorry, did I say September? Yeah. As I'm reading this, it's September 22nd, 2024. And page 2 reads, the record before the full court shall consist of the following: 1, all papers filed in the court case number; 2, the docket sheet for the court case number; 3, the party's statement of agreed facts; and 4, this court's reservation and report. This matter shall proceed in all respects in conformance with the Massachusetts Rules of Appellate Procedure. The defendant petitioner shall be designated the appellate. The Commonwealth shall be designated the appellee. The defendant's principal brief shall be filed no later than September 25th, 2024. The Commonwealth's brief shall be filed no later than October 16, 2024. The defendant's reply brief and if any, shall be filed no later than October 25th, 2024. Enlargements of time should not be anticipated. Oral argument shall take place in November 2024 or such other time as the full court may order. By the court, Elizabeth N. Dewar, Associate Justice, and it was entered the 19th, so just 3 days ago. So they will be hearing the oral arguments. It does not necessarily mean that they will be considering the appeal. This is not a consideration for an appeal. It's more so the appellate court saying, we will hear you on your arguments and then we will proceed. And I'm not sure what the legalities are, but I understand that once it's officially being appealed and it's going through the appeal court process, then the retrial that is scheduled for January is supposed to be put on hold. I'm not sure it's going to be put on hold if the court is only permitting oral arguments for the time being. So we will see. But it's enough that the Supreme Court is at the very least willing to listen to it so soon. As I understand, it's very difficult. The appellate court process is a lot more difficult than the superior court process. And sometimes it takes a long time for people to appeal something because there's a wait list. The appellate court is full, So I don't know if they're rushing this because of I don't know about rushing it, but I don't know if they're scheduling these oral arguments so soon within the next few months of this year because of the retrial, or if they're considering this case so soon because of its high profile nature. I don't know. But I'm just saying, guys, I am fully aware that when people try to appeal decisions made in the Superior Court, it usually takes a long time and it's very expensive. And sometimes the appellate court has a long wait list of people trying to appeal their cases. So we will see how it all plays out. But I am so impressed by Kieran Reed's defense team. And they're fighting the good fight. They are fighting the good fight. Thank you for watching.